let everyone take their seats, so we'll get started so we can start on time. I'm Alana Gallant. We are so pleased to partner with the Federal Society on the Supreme Court preview event for the third year in a row. We're fortunate to be joined by so many Federal Society members, in addition to our friends and supporters of the Manhattan Institute. I'd like to acknowledge Manhattan Institute trustee, Ken Gilman, who's in attendance this evening. Thank you all for your continued partnership and support. At the Manhattan Institute, our legal scholars, including tonight's panelists, Ilya Shapiro and Jim Copland, and my directors of constitutional studies and legal policy, respectively, have filed countless amicus briefs and have worked tirelessly to defend equality before the law and help improve the quality of governance by promoting transparency, accountability, and evidence-based reforms. Tonight's discussion will serve as a deep dive into the high-profile and thought-provoking cases to be presented before the Supreme Court during this upcoming term, and will highlight recent trends and cases still making their way through the federal court system. Before we turn it over to the panel, I'd like to introduce tonight's moderator, the Honorable Stephen Menashi, U.S. Judge of the U.S. Court of Appeals for the Second Circuit, where he has served since 2019. Previously, Judge Menashi served as Special Assistant and Associate Counsel to the President in the White House, and as Acting General Counsel at the U.S. Department of Education. He has held professorial and research fellow positions at George Mason, Georgetown, and NYU Law. He was a partner at Kirkland and Ellis, and clerk for Justice Samuel Alito and Judge Douglas Ginsburg on the D.C. Circuit. And last but not least, he is my husband. Thank you all again for joining us this evening, and now I'll turn it over to Judge Menashi.
We're having a change. All right, well, thank you very much, Alana. I'm happy to be here at the third annual Supreme Court preview. The Supreme Court this term is going to be considering a number of consequential cases involving Second Amendment rights, freedom of speech on social media platforms, and political control of administrative agencies. And so to give us a preview of what's in store at the court, we have three distinguished panelists with us. I'm going to introduce them in the order that they'll be speaking, and then I'll pepper them with some questions, but then I'll ask all of you to interject with questions at the close of the opening remarks. So first we'll hear from Ilya Shapiro. Ilya is a senior fellow and director of constitutional studies at the Manhattan Institute. Previously, he was briefly, but consequentially, the executive director of the Georgetown Center for the Constitution.
You used that line last year, and I've been repeating it ever since.
I did. And before that, he was the vice president of the Cato Institute and director of the Levy Center for Constitutional Studies there. He's the author of the book, Supreme Disorder, Judicial Nominations and the Politics of America's Highest Court, and the forthcoming book, Canceling Justice, The Illiberal Takeover of Legal Education. He clerked on the Fifth Circuit and graduated from the University of Chicago Law School. Next, we'll hear from Sarah Harris. Sarah is a partner at Williams & Connolly, where she works on the Supreme Court and appellate litigation practice. In the last 3 terms, she's argued 5 cases before the Supreme Court and obtained 1 summary reversal. This is in addition to many other arguments in the federal courts of appeals and the state appellate courts. Before joining the firm, Sarah served as a deputy assistant attorney general in the Office of Legal Counsel in the Department of Justice, and she previously clerked for Justice Thomas on the Supreme Court as well as on the First and D.C. circuits, and graduated from Harvard Law School. And third, we'll hear from Jim Copland. Jim is a senior fellow and director of legal policy at the Manhattan Institute, where he develops ideas about how to improve America's civil and criminal justice systems. His latest book, The Unelected, How an Unaccountable Elite is Governing America, was published in September 2020. He has testified before Congress and state and municipal legislatures, and he writes regularly in the Wall Street Journal, the New York Post, and other publications. Earlier in his career, Jim was a management consultant with McKinsey & Company and was a law clerk on the Second Circuit, and he went to Yale. So with those introductions, let's turn first to Ilya.
Great. Well, thanks all of you for coming. It's great to be on this panel. I guess, as Judge Menashi mentioned, our third annual, I guess the first, which I also was a part of, I was trying out because I ended up joining the staff of MI the following year. Well, I want to set the stage before we get into next term's cases. Because obviously the last 2 terms and then this last term were really consequential. And my Twitter feed and the mainstream media, pretty much the same thing. We're all aghast at how the court had doubled down on its right-wing extremism, right? It's not a normal court, said President Biden. I'm not sure what's abnormal about ending racial discrimination in higher ed admissions. But regardless, the American people seem to like what the court's doing, with clear majorities in the affirmative action case, strong pluralities in all the other big controversies. I guess half or more of the country is abnormal as well. And by the way, if you think that this is a kind of conservative right-wing court, you would think that Justices Alito, Thomas are constantly in the majority, getting their way. Those two happen to be the justices least in the majority this past term, and the justices who are most in the majority, Roberts and Kavanaugh, agree less with Thomas than any other justice. So look, the statistics belie the vibe. Sure, the last couple of days of the term had some good wins for those of us probably certainly on stage, probably in the room as well. But overall, the court is, all the justices in good faith work hard to get the law right as they see it. All right, let's turn to this term that just started today. Big case tomorrow, I think, that Sarah's going to talk about. But I'm talking about first a Second Amendment case. It may or may not end up being a big one. We'll see. This is the first case since Bruin established a right to carry. Well, what about the Second Amendment right when you have a civil protective order against you? So someone has committed some domestic violence, not for purposes of being charged with a crime, but for getting a protective order. Can that person still have a right to bear arms? The court will likely use this as a way to impose some sort of dangerousness or propensity of violence standard, according to the history and tradition test that Bruin established. There were no domestic violence protective orders in 1791, nor in 1868 when the 14th Amendment was ratified, but there were understandings that people who were violent might be disqualified in certain ways. So Justice Barrett, when she was on the Seventh Circuit, wrote a dissent about how incongruous it was to impose lifetime dispossession on people with, in that case, non-violent 30-year-old felonies. We'll see if she's the one who writes, or Justice Kavanaugh also has written about history and tradition with respect to the Second Amendment. But this is going to begin to flesh out how judges are going to apply the Second Amendment. Two big property rights cases were granted just this past Friday, the result from the so-called Long Conference, when the court evaluated petitions that had been briefed up over the summer. One looks at whether you can make out a takings claim that your property was taken without just compensation, where there's no federal or state law that provides for it. That is, it's kind of a common law takings, if you will. Pretty stark facts, because a few years ago, the court said you didn't have to run the gauntlet of state administrative courts before bringing a federal takings clause Fifth Amendment claim. If in this case, there's someone whose land was flooded by sound barriers that were built next to a highway. Those are the particular facts. But I imagine the court is going to find in favor of the property owner, because there was real damage, and whether there's codified law shouldn't matter for constitutional purposes, but we'll see. And Sheets versus County of El Dorado, California. MI had actually filed a brief supporting cert in this case, and it involves exactions or fees or unrelated burdens that someone who wants a permit to build has to pay. In this case, the issue is whether a permit exaction, something that you have to do to get your building permit, violates the unconstitutional conditions doctrine, even if it's been legislated. It's not just the clerk or the zoning board acting pursuant to its own discretion, but the legislature has said that you can assess these kinds of exactions. Kind of technical, but important for the lawyers. This is a Nolan-Dolan case. And then on the theme of social media, which Judge Menashi broached, O'Connor-Ratcliffe versus Garnier and Linkey versus Freed. not going to be a marquee social media case, but it does start developing First Amendment law in this area where public officials, in this case school board members, block people on their private or campaign social media accounts, even though they talk about government or official actions on those accounts. You might recall Donald Trump ran into this, and the Second Circuit ruled against him, which was then vacated when he left office. Well, here I think we'll have a ruling that will stick one way or another.
Can I ask what you expect to come out of the gun case? So I read the government's brief in that case, and they said, well, there's a long history of disarming persons who are not law-abiding and responsible citizens, which is just a quote from Heller. And it seems like the government wants to say, well, just go back to Heller and don't really apply something special in Bruen. Do you think it's going to be a retreat from Bruen-type review, or it's going to be some kind of elaboration and retrenchment?
Well, I don't think there's a way to go back to Heller because Bruen was not changing the Heller standard, nor was McDonald, which applied Heller to the states. Bruen was about carry, Heller was about a ban altogether, and so I think that they're going to, because lower courts have been, your jurisprudence has been brilliant, of course, but some other lower courts have been confused about how to apply the history and tradition standard, and so here we're going to get some flesh on those bones. And as I said, there is evidence that, it's bad originalism to ask, what did James Madison think about violent video games or, domestic, protective orders for domestic violence in 1868. But how did lawmakers or other officials at the time treat people with a propensity for violence who didn't have a felony? Because at the time, the only felonies were all violent and what have you. So I think we're going to have that kind of historical discussion. Is there evidence of dispossessing, with due process protections, people who have a propensity for violence but haven't been convicted?
Okay, Sarah.
So I get the administrative law docket, which is very exciting to me, and hopefully some of you. In a term where the conventional wisdom is this is a lot more boring than, say, like the Dobbs term or last term, where we had affirmative action and student loans and 303 Creative, the case about those sort of pitting religious liberty and free speech against LGBT type laws. Like this term, the marquee cases really are administrative law, which can feel a little sort of more abstract. I think they're really important because in an era when Congress is doing less and less, presidents obviously rely more and more on administrative agencies to do stuff. And administrative agencies have quite a lot of power. And so I think people have been teeing up fundamental questions about what can they do, what kind of political checks are there on them, can you have sort of in-house agency proceedings where agencies are acting a lot like courts? If you have those, what checks are there on the agencies or not? Can you have agencies that are essentially self-funded? These are all the questions on the Supreme Court's docket, and while they sound very abstract, they are really fundamental questions about how democracy works. So I care about them, hopefully you care about them. The fun thing about this term as well is there are 3 just enormous administrative law cases, any one of which would be just a sort of 10-year big case. And the government sort of has to run the table and win all of them to keep the status quo. So even in a world where the government doesn't win all of these cases, I think you could still see very significant changes to the administrative state. And I think that's important to keep in mind because you sort of see a lot of news coverage that says this case will end the world, depending on how it comes out. And then, it turns out the case may or may not come out the way that the mainstream media is covering it. In administrative law, each of these cases really does matter. So let me just sort of talk about them really fast. The first one is a case called Loper-Bright Enterprises versus Raimondo, which is commonly known as the case about overturning a doctrine called Chevron. So the Chevron doctrine basically is a big thumb on the scale for administrative agencies. The idea is if Congress has enacted a law that lets the agency interpret a law in its course of business, and the agency comes up with a reasonable interpretation of the statute, even if it's not the best answer, the agency is supposed to win, just kind of automatically. Courts are not supposed to say, I'm going to look at this myself in the first instance. They're supposed to say, I defer to you, agency, that is charged with implementing the statute. And if you look at what happens as a practical matter, that thumb on the scale can matter a lot in cases. So the premise of this case is, should the court overturn that doctrine? It's a big case because the Supreme Court had turned down many, many, many requests to overturn Chevron in other cases. Now, I suspect they took this one because it involves herring fishermen in a statute called the Magnuson-Stevens Fishery Act, which is like a big deal for people who are fighting over tuna fisheries and the allocation of fish, but not as big of a deal as, say, like some of the other contexts in which agencies are deciding big statutory questions. So it kind of takes the temperature down in terms of the factual context, which I think is why the court took it. It's such an interesting case as well because the government and the challengers are almost two ships passing the night. The challenger's position is, look, Supreme Court, you've almost overturned Chevron already. It's just an interpretive principle. It's not sort of a substantive holding saying that like X statute means a particular thing. You're just using a thumb on the scale like a presumption almost across a bunch of cases. So overturning it would not be a big deal the same way as, say, reinterpreting a particular, like the Environmental Protection Act might be. And on top of that, in the last sort of 5 years, if you go up to the Supreme Court and you try to argue a case and you mention Chevron, like you get a dirty look. Like not only a dirty look, but it's like the Lord Voldemort of like statutory interpretation. Like you don't mention it. You really don't. The Supreme Court has gone out of its way not to mention Chevron in its opinions, even when Chevron was like squarely teed up by the lower courts. So at least in the Supreme Court world, it almost feels like Chevron has already been gone. The problem and the sort of government's opposite take is lower courts are still very much addicted to Chevron. That is especially true in the DC circuit, where if you don't mention Chevron like as many times as you can, you're probably doing it wrong. A lot of cases do turn on Chevron there. And the government, sort of, its brief claims that there will be cataclysmic consequences if Chevron is overturned, and sort of sounds the theme of, what are you doing, Supreme Court? Why would you overturn another precedent? This is very aggressive. So really sort of two polar opposite positions on how important is it to get rid of Chevron, what will the consequences look like? And I think it's a legitimate matter of debate because as a realpolitik matter, there's just such a huge divide between Chevron being essentially a dead letter in the Supreme Court already versus Chevron very much being alive in the lower courts. And so I think the conventional wisdom is the court would not have taken this case if they did not want to take a giant whack at Chevron. And it's a case that came up out of the DC circuit and will be really interesting to see what happens. It's going to get argued in December. The second case, which—
Can I ask you a question about the Chevron case? So I think the conventional wisdom also is that the court's not going to explicitly overturn Chevron, but say, actually, we really mean that you should do all the tools of statutory interpretation before you decide to defer. If they do that, if they say it's really a last resort, would that cure the addiction to Chevron in the lower courts, or leaving it out there wouldn't actually address the problem that some of the challengers think should be addressed?
So there's almost like a last clear chance that's been happening with Chevron because the court has already said essentially Chevron is like truly your last resort, like break the glass, like even more so than any other canon. Really don't use Chevron unless like bottom of the barrel. And I think they took this case especially from the DC circuit thinking that perhaps the message has not been sort of like as many exclamation points as it might deserve. So I think for the courts to not overturn Chevron, there's a familiar feel of what you're talking about. There's another sort of parallel doctrine about deferring to agencies when they're interpreting the rulemaking that they do, where the court did a similar move a couple of years ago. But that was a different court. We now have more newer justices. Justice Ginsburg participated in that one. And I think that for the courts to not overturn Chevron, they would probably do something more aggressive than just saying, like, don't use it normally.
Oh, but that means you're suggesting that you think actually it's likely that we will see an overturning of Chevron.
I think it could be a similar move to the Harvard case where it is essentially overturned, but
it doesn't say so explicitly.
I think that's certainly on the table. And that's something that the petitioner has preserved in the way they frame the question as well. And I think that's wise. I mean, the court, again, there's sort of a tension between some terms where the court is much more willing to overturn precedents, the Dobbs term being a good example, and this past term, the court really almost seeming to bend over backwards to not at least nominally overturn precedents and come up with outcomes that look a lot like overturning precedents, but are not formally overturning them.
CFPB.
Sorry, CFPB. Next one. There's so much on the chopping block. It's really interesting. Second case is about the appropriations clause. So
This is the one that's being argued tomorrow.
being argued tomorrow, and if you're looking for an argument to listen to, this is a great one. It pits former Solicitor General Noel Francisco against current Solicitor General Elizabeth Freelager on a fascinating question, which is it constitutional for Congress to fund an agency by essentially letting it decide how much money up to a very large cap it wants for itself? So basically, the CFPB can go to the Federal Reserve, which funds itself through collecting fees from various members of the Fed. And then the CFPB can say, I want up to 9 figures to fund my own operations. And that is designed to give the CFPB a lot of independence. The challengers say you cannot have an agency that essentially gets to write its own checks. Congress cannot delegate to agencies that much discretion over how they fund themselves. And the upshot should be that all of the CFPB's rules are not valid because an agency that is improperly funded shouldn't get to act. The government's position is the CFPB is fine. Going back to the founding, the government points to examples of agencies that funded themselves through fees, and the government says this is not that different from that. So it's just, again, a really interesting case that is a massive question about the CFPB, which is one of the more controversial newer agencies, has a lot of power over all sorts of areas of finance and rulemaking with respect to just how consumer lending practices work, and whether that agency will be able to keep operating. It feels like the agency with 9 lives. It's been before the Supreme Court a lot of times on other constitutional questions. So I think it'll be interesting to see what the court does. It is not a common separation of powers type challenge that the court hears. There are not a lot of cases about are there limits on how Congress can set up a mechanism for funding agencies. So it's sort of a chance to break new ground for the courts. And I think you will hear a lot if you listen to the argument about what is the history of different funding mechanisms and why or why not are they historically justified. And then the third case is almost like 3 cases in one. It's called SEC versus Jarchese. Comes up out of the Fifth Circuit, which said that the SEC's method of adjudicating when it goes in-house, so let's say that you are someone that the SEC accuses of committing securities fraud. They hail you before the agency. They can choose not to go to court. They can choose to go in-house in the agency, have an administrative law judge who's part of the executive branch proceed against you, sort of feels like a court, have that judge say that you should have very hefty civil penalties issued against you, and then the SEC commissioners sit in judgment and say, oh yes, I agree, there should be civil penalties. And so that's one method of getting civil penalties just enforced against you. The Fifth Circuit said you can't do that for a couple of reasons. The Fifth Circuit said the Seventh Amendment and Article 3 guarantee people the right to a jury, and the right to appear before a federal court if you're going to be prosecuted for fraud and have this kind of civil penalties. The Fifth Circuit also said that there is a problem with Congress delegating to the SEC the ability to choose between going in-house or going to a court. And then finally, the Fifth Circuit said, in addition on this constitutional issue spotter, you cannot have administrative law judges who are not responsive enough to the president. You can't have them to be completely insulated from the president or someone removable by the president in how they're operating. There's just too much of a sort of segregation of those people from the president who's elected by the people to be constitutional. So that's quite a doozy. I mean, any one of those holdings would be a very, very big holding that would affect a lot of other administrative agencies.
Thanks very much. Jim.
Yes, thanks, Judge Menashi, and thanks everyone for coming here. The stuff I work on here, this is legal policy. I mean, these are constitutional lawyers. This is our director, and this is what she does. And I work on these law and economics policy questions. Most of my stuff rarely gets to the Supreme Court because it's either settles, class action securities stuff settles, or we're talking about agreements, deferred prosecution agreements with the government and other people, or what have you. Certainly some of the security stuff I work on, it's no action letters, et cetera. But there's some things percolating. We'll talk about that in a minute. But the 3 issues, the 3 cases I'm going to talk about today are all in that sort of policy, law, and economic space, at least tangentially, and they're all core policy issues that have been important historically here to us at the Manhattan Institute. So the first one is not a constitutional case. The other two are. The first one is a statutory case, Macquarie Infrastructure versus Moab Partners. And this involves what's called 10b-5, fraud on the market liability. It's from Section 10b of the Securities Exchange Act of 1934. The Securities and Exchange Commission's promulgated Rule 10b-5, and courts interpreted, they inferred what's called an implied private right of action, the ability not only for the SEC staff to come to companies and enforce and say, oh, you've misled people in your statement on your 10K or your 10Q, but to allow private rights of action so that an individual investor who's bought or sold securities can sue with counsel, and then later the lower courts and ultimately the Supreme Court countenanced class action sorts of litigation in this context as well. So there's a circuit split that's arisen between the Second Circuit, where we sit here. Judge Menashi wasn't on the panel of the case, which is summary order that's getting, which means it's an unpublished opinion without precedential value, decided here on the Second Circuit. But it was unpublished for a reason, because in 2015 there was another case that made a decision for the Second Circuit that's in conflict with the Ninth Circuit and some other circuits out there in terms of how we interpret two interlocking provisions of the regulatory code that the Securities and Exchange Commission develops. Rule 10b-5 and then item 303, which is part of the regulation SK disclosure, which is a disclosure rule. Now, it's important to understand 10b-5 is not a disclosure rule. Generally, our federal securities laws are all about disclosure. They are disclosure rules, as opposed to the substance of corporate law. Fiduciary duties, by and large, are matters of state law, state corporate law. But 10b-5 is basically the mechanism where if you want to sue in federal court against a corporation and say they've defrauded us and caused my stock to go down, that's the hook that you use, is 10b-5. But the two things about 10b-5, it's not independently a disclosure rule. And B, it is not generally, you can't sue under 10b-5 based on omissions in general. You sue based on statements of fact that are false. I mean, there is language in there in the rule, any untrue statement, but it also says to omit to state a material fact necessary in order to make the statements made in light of the circumstances under which they were made not misleading. And so there is that provision, and that's where we've gotten this sort of split between the circuits on this when it comes to item 303. Now, item 303 is a very general sort of forward-looking, it's basically management analysis rule. And some of these are optional, some are required, but the SEC basically wants the management to say, well, if you think something's important, give your opinion, put it in there for investors to hear about. And what the Second Circuit decided, in contrast to the Ninth Circuit, is basically that if you come out and say, basically that if you don't say something under 303, you can bootstrap that into a fraud action, a private lawsuit under 10b-5. And the Ninth Circuit said, no, you can't do that. 10b-5 is not about that. There's a different materiality standard, et cetera. And that's the circuit split that's arisen here. We've been working on this a long time. I've done a lot of sort of work on securities litigation. The Congress actually acted in 1995 over Clinton's veto, the Private Securities Litigation Reform Act. It's a huge, big-ticket type of litigation, almost always settles. The court granted cert on the circuit split some 6 years ago, and then the case settled, which mooted it, so they never heard the case. Now there's another opportunity to go back, and they've just granted cert again, and not surprising given that they did before. What are they going to do on this? My instinct is, to grant cert, you only need 4 of the 9 justices, so who knows what a majority. My instinct will be here that the Second Circuit rule is going to get knocked down, and it's going to get knocked down because the court, while it has resisted overturning this sort of fraud on the market litigation, which was established in a case at the Supreme Court level, in a case called Basic v. Levinson in 1988, it's resisted that. It looked at it 20 years later in a case called Stonebridge. But what it has done is said, we're not going to push it any further. And I think this is going to be characterized as we're going to push this further. We're going to open up new channels of 10b-5 liability through a different provision. And there's new justices that weren't there in some of these other cases. But certainly Alito, Thomas, and Roberts in other cases held that sort of position. We're not going to push the envelope of securities class action litigation. So my guess is that's where it's going to go on this, but that's without merits briefing or argument yet, so that's just a guess based on the facts. Next case is a case called Connolly v. Marshall, Marshall being the Attorney General of Alabama, and this is what we talk about when we talk about civil asset forfeiture. This has been an issue that Manhattan Institute's worked on. A lot of other independent, like libertarian, freedom-loving organizations have worked on. And civil asset forfeiture is basically the government takes your stuff that was involved in an alleged crime, and they keep it for a good long while, and it's hard to get it back. I mean, that's the basic theory. And we have a brief in this that Ilya submitted on behalf of Manhattan Institute alongside Pacific Legal and Goldwater in that case. Right. And it goes through all the history of this. And this is something that the founding generation would have been quite skeptical of, but it's become a big thing. It's become a big thing precisely because it's actually used to fund a lot of sort of local municipal police forces and things like this. And so what we've got here again is a circuit split. The 11th Circuit, where Alabama is, used one test. And there are two different tests being applied here from two 1970s cases. One's a due process clause test. The other is a speedy trial test. Alabama and the 11th Circuit have used this speedy trial test, which basically means, well, you can wait a long time, and if ultimately you can get a trial within the Speedy Trial Act or the Sixth Amendment treaty speedy trial, which is a weird thing to apply here because it's a civil asset forfeiture. It's not criminal. These cases are both ladies who lent their cars out, one to her son, one to a friend. They were doing some drugs. They took the car. The women can't get their cars back. I mean, that's what these cases are about. And the speedy trial is about criminal stuff. It's a civil asset forfeiture case, but they've applied that. Other circuits have applied a sort of more ordinary due process analysis here to make sure there's fair process, and it gives people a little better chance to get their stuff back sooner. So it's potentially a really important case. My guess is the 11th Circuit rule will go down.
I'd kind of like to make sure we have time for questions from the audience, so maybe we can do the
His
next
last
one.
case is really important.
All right, maybe we could do it quickly. And then
Save the best for
turn to
last.
the
I'm
audience.
sorry if I've rambled too much. The last case is the tax case, and this is Moore v. U.S. Obviously, tax has been something important to MI since the beginning. We supply-side taxation, et cetera. This is about the 2017 Tax Cuts and Jobs Act. This is the Republican Trump tax cut bill. The big meat of that bill, obviously we had things like SALT deduction and everything else, but the big meat of that bill was corporate law, tax cuts, and as a piece of that, which was to make the U.S. competitive, because we were getting these situations where we were inverting our companies and they were going to be abroad where they get lower corporate tax rates. But as a piece of that was a provision where you could claw back a one-time repatriation tax if you were a 10% or more owner of a foreign business and get hit with that tax. The plaintiffs here are sympathetic plaintiffs, these people, the Moores. They invested years ago in this business in India, which they did as more of a social justice thing. They don't have any control over this business. They haven't got any dividends back. And then they're hit with thousands of dollars of taxation under this law. They brought suit under this. And the basic premise here is for the income tax, does the direct apportionment clause and it appears twice in Article 1 of the Constitution, basically saying that direct apportionment applies when it comes to tax that is a direct tax as opposed to an indirect tax. So you can have excise taxes or import duties federally, and Congress has discretion. If they do any other sort of tax, they can do that, but it has to be apportioned based on the population of the states. And the income tax amendment, obviously, in response to the Pollock case in 1895, said, well, no, you don't have to apportion that for income taxation. That's the 16th Amendment. But the court has traditionally said that you have to have realized income. So you get a dividend, you sell stock and get a capital gains, you get cash coming in, they can tax that cash. You can't just tax holdings that may have appreciated without any income coming in. I think that's the traditional view. My guess is the plaintiffs are going to win in this case too, but we'll see. But it's a big case, and the broad implication here are for things like the wealth tax.
Yeah, that's what I was going to say. It has implications for that.
Elizabeth Warren and these folks say, we want a wealth tax. And the way they would do a wealth tax is kind of like this. It's like, oh, you're holding wealth, you made a bunch of money, you haven't realized that income, we're going to tax it anyway. And I think the court will draw a line here that basically says you're not going to be able to do that without a constitutional amendment.
Okay, well, that's great. Thank you very much, Jim. If anyone in the audience has a question, please raise your hand. There are people walking on the aisles with mics, and so they can bring one to you. Why don't we take this question here?
I don't really need a mic.
Okay, go ahead.
With a mic, I heard today that the Supreme Court denied cert on the various cases coming out of New York on rent regulation. And I'm wondering why you think they denied cert and what would have happened had they taken up the cases.
So this, it's a complicated thing because there were 4 different petitions involving rent regulations, 3 of them out of New York, 1 out of California. They denied 2 of them today. 2 others, both from New York, are still pending. The major difference about what is still pending is that they have challenges to regulatory takings under the the Penn Central doctrine, which basically makes it impossible to win against the government unless the regulation takes essentially all of the value of the property. And there might be multiple things going on here. One possibility is that 1 or more justices, up to 3, is writing a dissent from denial. And it's going to take a while to finish that dissent, and because it takes 4 votes to grant, so it can be up to 3 justices if they're dissenting from denial. Another theory is that it also takes a while you don't necessarily automatically grant. They might what's called relist, meaning look more and more at what's the suitability of the particular case. Are there any other kinds of defects, vehicle issues as lawyers call them, so they might be giving it a harder look. Another thing is the 74 Pinehurst case, which is still live, has as applied rather than facial challenge, meaning just for those particular plaintiffs versus the law itself in all applications is improper. It's all speculation. We won't really know, but the case that we featured last week, I was in New York beginning of last week to do a dinner with Andy Pincus, who was the lead counsel on the CHIP case. So that one was denied, but there is still another case in which we also filed, this 74 Pinehurst, and yet another one that's more technical. So we'll see what they do. We'll know maybe the end of this week, beginning of next one, maybe not.
Do you have other questions from the audience? Why don't we take that question there?
Hey, my name's Will Simpson. I had a question for Sarah, or I guess anyone, about the CFPB case. One thing that we may hear a lot at oral argument tomorrow is if the challengers win and if the funding structure of the Bureau is unconstitutional, what the remedy is. And the government loves the parade of horribles that we're going to invalidate a decade of rules. From the Bureau, what do you think the court should do or will do in terms of the scope of the outcome and the effect on past rules the Bureau has issued?
I love this question because the remedy for separation of powers type violations is the thing that people tend to overlook and is probably the biggest driver of a lot of the decisions. I think if you look at some of the past decisions, the court, at least just as a practical matter, seems very reluctant to upend the apple cart by granting retrospective relief that would invalidate a lot of past agency actions. Whether that is right or not, like the current precedents in various contexts make it really, really hard to get retrospective relief in certain cases. So I don't know what the court is going to do. I think one question is if they get there, they have a lot of options on the table. The challengers point out that in past cases, the court has essentially said, we're going to freeze, we're going to tell Congress they have a period of time to fix this, and that may well be the easiest answer because then the court does not sort of have to blue pencil the law and figure out what would Congress have wanted, what should the relief look like. The court can sort of say, Congress, this is your job, go do your job. Other options are a little more complicated, both in terms of whether the court can effectively rewrite a statute in a situation where there's a fair amount of contemporaneous evidence that Congress really wanted this agency to be super duper independent. Hard questions about, can you then kind of make the agency less independent permissibly under the doctrines the court kind of uses for that. And then really hard questions, just very hotly contested on both sides, about whether the appropriations clause and like having a situation where the agency is operating without proper funding is the kind of defect that should be sort of something that means they can't act at all lawfully, or is it more like situations where the court said, you have this power to act, you didn't quite, you didn't act properly, but we're going to look if there was some sort of prejudice. And it's just sort of unknown. I think the lesson of the past separation of powers cases is they have a lot of potential analogs to look at, and that's why I think this is almost the most difficult part of any separation of powers case. So I don't know.
I mean, the one weird thing about this case, Sarah's exactly right, but Congress is saying we want it to be independent of us in terms of our appropriations power. I mean, it's a little different than the case we had previously where it's, we want the director independent from the president, or these sorts of cases. It's like, the court could say, I don't think the court's going to throw out all the bodies of regulation or whatever, or kill the agency per se, but they could say, well, listen, if you want money, Congress needs to give you the money, right? I mean, that would be an easy fix, I would think. And I'm not saying that's what they'll do, but it is a weird sort of situation. We want you to be independent of us.
I'm going to take this question here.
I'm not 100% sure if this relates to the agency funding or whatever, but I find it amazing that we have a budget, the executive branch needs appropriations to do it, and so President Biden spends $500 billion or $1 trillion on something that clearly is not in the budget. I'm talking about debt reduction. So, why does it matter? Does Congress actually control spending at all if that kind of thing could go on?
Does anyone want to?
I don't know if that was a question about student loan cancellation, which spends money in a different sort of way, but the president can't just, doesn't have a slush fund to just spend from. So the president does execute, so there's discretion of different agencies to spend money in different ways. So it just depends on the specifics.
The question of the student loan cases was whether the president had the authority to cancel the loans or modify the loans, right? But as we know from the recent shutdown debates, the government does need appropriations in order to keep operating, and so that does promote a kind of accountability to Congress. Why don't I take this question here?
Thank you. This is an interesting conversation. Recently, Justice Gorsuch seems to have been the biggest advocate for Native American tribal rights, and I'm curious as to if you could expound on your thoughts on why he seems to be the most vocal proponent of that, and if there's any case that's currently on the docket or may come that could be the next one that he will take up.
Anyone have thoughts about?
Well, he's the only justice from the West, and from Colorado. He took a particular interest in Indian law on the 10th Circuit and in general, and I guess sees it as a place where he has a comparative advantage on the court. I do not know enough about that area of law to evaluate whether he gets it right.
Why don't I take that question there?
Jim, you mentioned the McGuire case. Do you think there's any chance other causes of action, say Section 11, may be implicated besides 10b-5?
Say that again. Which case?
The McGuire case.
Oh, the McGuire case.
Up on Friday.
Is that how you say it?
It's
Macquarie. Okay.
Yeah.
The way it's framed, right now it's just been granted cert pretty recently, right? So the way it's framed is teeing up this 303 versus 10b-5 sort of question. I think they'll hold it to that. There is more consensus among the circuits that 303 can be involved in basically imputing to other sections where you have agency enforcement, right? I don't think they're going to touch that in this case. Obviously, depending on how the justices handle this case and how they discuss it, might feed future litigation, right? Depending on how they frame it here. But I think it's going to be narrowly tailored to 10b-5, and it's, can you bootstrap a 303 omission cause of action to generate a private cause of action under 10b-5?
You keep talking about 303. It makes me think of 303 Creative, the
Right.
case from last term, and with Taylor Swift going to Chiefs game and all this, whether once the inevitable breakup happens, now with the 303 Creative ruling, she won't be able to be forced to write songs hailing the Chiefs. Anyway, sorry for the discursion.
Let's take the question in the back.
I have a question about the tax case. So if the issue in this case hinges upon the definition of income, whether it's distributed or not, there's a whole variety of entities that are tax pass-throughs. I think it's uncontroversial. Partnerships, LLCs, which if they're those entities of income, then the taxable income passes through to the holders regardless of whether cash is actually distributed or not. It's very widespread.
Yep.
I think it's uncontroversial. Will this case have impact on those kind of structures? Basically every kind of partnership?
That's a big complication. I mean, I've thought that's a big complication since I saw this case. I mean, what's your thinking? I mean, we filed a brief on this case too, a good one with some.
I've been on a panel on this case, and that did not seem to be a concern by either supporters or opponents. So I'm not sure, but I'm not certainly no expert on pass-throughs.
I mean, yeah, you don't. I mean, I've paid tax. I've paid tax on a subchapter S corporation that I was a greater than 10% owner and director of. That I had passive stock. That the corporation held income even when there were operating losses, and while we had an agreement to pay cash out, we didn't get. Yeah, I mean, this is very common.
They take in and they pay out, right? So there are realizations.
Right, but you don't. Yeah, if you are a passive owner and they're not writing you checks to cover your tax liability, you still have to write the tax liability. This is very common. So every sub S and a lot of partnerships are going to be structured that same way. So it could be a really I'm sure there will be a lot of thinking about that. I don't know. I don't know that the justices will get into it. I haven't read all of the amicus briefs and everything on that. I haven't seen that really discussed, but I do think it's a
This is the
question.
Moore case, by the way, in case anyone missed it, if you want to look it up.
Here in the middle.
Yeah, so I have a question about the role of the SEC and also bankruptcy courts in like the case Purdue Pharma. So basically my question is, do you think that non-Article 3 judges and agencies who kind of perform a judicial role should be unconstitutional?
And that is one of the questions, as you alluded to, that the court will be thinking about in the Jarchese case. I think they framed it a little differently, which is the basic line of the cases is there is some role for agencies to adjudicate certain types of issues, so-called like public rights, where if the government is essentially giving you a privilege that they have some discretion over, sort of like Social Security or other stuff, the government can decide what happens with those types of rights in-house. But the distinction is sort of like for private rights, like the traditional sort of like contract rights or traditional rights between private persons, there's a much more difficult bar to show that agencies, as opposed to courts, should be adjudicating them. So I think there is the hard question in the SEC context, and I think some other context, is what kind of rights is the SEC actually adjudicating, and are there real limits on what agencies are allowed to do depending on your characterization of it? I think the court has really struggled with that question, certainly in like the patent context, how to classify patents. Are they things that are essentially privileges granted by the government? Are they more like private property rights? There's a whole line of cases on this stuff, and the court does tend to have a hard time just figuring out where to draw the lines. But it does sort of seem like whatever the answer is in this particular case, the court will probably say two things. One, public rights are different, agencies have something to do, but on the other hand, there are definite limits that have to go to federal courts. And that's important, I think, for accountability and also just in defining what kind of penalties and what kind of coercion can agencies impose on people at the end of the day before you can even challenge them in court under a deferential standard.
I think there was a question here in the front. Oh, okay, we could go there, and then we'll get you next.
Hi. This is a question more about the history of the Supreme Court and the Supreme Court as an institution in our democratic society. Do you think it's right or wrong for Justice Roberts to try to leaven the affirmative action ruling that he was in the majority with the Alabama redistricting congressional case? Does the Supreme Court, through Justice Roberts, try to leaven or even the playing field sometimes at the end of the term when decisions are announced that kind of have a significant impact on large elements of the society?
I'm not a fan of Chief Justice Roberts' strategery. I'm not sure that's an example of it. I mean, that's the conventional wisdom or the conventional kind of punditry that, oh, he knew this was coming, so he took the election law case the other way, or both of the election law cases. I think that's just the way they came out, and it belies the narrative that this is always to the benefit of Republicans or conservatives or what have you. At base, the Voting Rights Act is a very different area of law than equal protection in the educational context. And what the court did is just decide not to overturn the Jingles test for when and how much race can be considered. So I'm okay with what the Supreme Court did. What the three-judge district court has been doing, however, I think is reading much more into those requirements. This is getting a little bit into the weeds. I had a Wall Street Journal piece about the new map that Alabama put out after the Supreme Court ruling and why I thought the new map satisfied the Jingles test and the court's ruling in Allen versus Milligan. But anyway, I don't try to complicate or conspiracy theorize things. Allen versus Milligan was a 7-2 decision. I don't think it's just Roberts trying to do balance race cases.
I said we'd take the question here in the front.
Hi, my question was actually to do with the Loper Bright case. If the court were to...
This sounds like a fishing expedition.
Yeah.
Or a red herring.
One fish, two fish, red fish, blue fish.
It's a two-parter. But essentially, if the Supreme Court were to overturn the Chevron doctrine of interpretation, what do you think would be the broad implications? And secondly, do you think that, like you mentioned, this is a more softer sort of legislation because it's fisheries. Do you think that it might open floodgates of sort of petitions to the court for interpretation of other more critical administrative agencies' rules?
So the two-part is important. On the first question, do I think what exactly would happen if the court overturned Chevron? Again, I think you can kind of just do a comparative study in some ways of courts of appeals. The DC Circuit, obviously, very much like Chevron. The agency is much more likely to win in the DC Circuit. The Supreme Court and some other courts of appeals sort of not as much fans of Chevron, and the agency will win less. At the end of the day, I mean, if the question is the agency putting forward the best view of the law, the agency will win no matter what. So that's why it's kind of hard to handicap. I think the question is, how often is the agency winning because it gets deference as opposed to because it has the best reading of a statute? And that's why it's just kind of hard to handicap, at least prospectively. I think courts will just reason those cases differently and say, we are looking at the statute, and the agency either wins or it doesn't, but it's not winning because it gets an extra thumb on the scale. In terms of what will happen with previous regulations, again, the government's position is, the sky's going to fall. A lot of previous cases saying that an agency interpreted a statute a particular way might be vulnerable. Again, I guess I could read that with a grain of salt, because under the Chevron regime, agencies have been able to change their readings of statutes already, and so there's sort of some instability baked into the idea that what you're doing is not necessarily adopting the best reading of the statute. It's saying there's many readings out there. The agency can adopt reading A sometimes and reading B if it likes that one in a different administration. So that kind of built-in instability, I feel like sort of may well undermine the extent to which, even with respect to cases where the agency won based on deference, there will be a difference going forward.
Can we take one last question, or are we done? Is somebody going to give me a signal? There was one here in the front. Let's do this last question.
I'll repeat the question. He said, how is the ethics code debate going to play out? Is the media just going to move on? Is there going to be some result?
Does anyone want to?
Look, I mean, I've thought about this some. I think, the attacks on Alito and Thomas, mostly, some others have gotten involved, but it's mostly sour grapes by left-wing activists who don't like the results of the court. I mean, is it seriously the case that because Justice Alito went on a fishing trip to Alaska with MI's board chairman, Paul Singer, 15 years ago, or now 18 years ago, that's why he eventually voted to overturn Roe v. Wade? Or Justice Thomas would have been like a swing vote right there in the middle, except he, went to Harlan Crow's, whose wife Kathy is on our board. I have to issue these disclosures, right? He went to hung out with them, and then got all of his insight into the true meaning of the Second Amendment. I mean, it's laughable, right? And he was following there are new disclosure rules now since March of this year. Anyway, this is all a smokescreen. Maybe they'll all agree to something. I'm not sure what it is. As it is, they voluntarily follow the lower the code that applies to lower court judges. Obviously, there's more scrutiny, but the countervailing argument is that if a lower court judge recuses, someone is there to fill that space. In the Supreme Court, there's not, and so Justice Scalia's 20-page, I don't know whether we characterize it as a memo or response or what filing or what have you, when he was asked to recuse from a case involving, I think, was it Dick Cheney's hunting buddy or something? Anyway, I think it's apt, because so that duty to sit, unless it's absolutely, Abe Fortas style corruption, which I've also written about for the Wall Street Journal, I think is apt. So will they eventually agree on something? Maybe. Will the media move on? No, because they want to attack the, right-leaning Supreme Court.
All right. Well, I think we're at time, so you can come up and talk to the panelists after. But well, if somebody wants to say something about that briefly.
The leak, until at this point, unless the leaker discloses him or herself, I guess we just won't know. It's unfortunate. It's a damaging episode.
Okay. Well, with that, please join me in thanking our panelists.